Welcome to our last session of the day on the new marketing rule. We are the last session, but by no means this is the least important topic. As John mentioned, we have a lot of resources on our website, and there's a lot of IAA member interest on this topic. So I'm super excited to be moderating today's panel. As John said, I'm Sanjay Lamba. I'm the Associate General Counsel at the IAA. So let me start off by introducing our fantastic panel. So first, Pam Pendrell. She's the Chief Compliance Officer and Partner at GlobeFlex Capital. She's based out in California. Joining her is Mike McGrath. He's a partner at K&L Gates in the Boston office, and Mike has extensive experience on matters involving investment advisors with a particular interest in advertising and performance advertising and gifts in particular. So thrilled to have Mike here as well. And then last but not least is Melissa Harke. Melissa is a Senior Special Counsel at the SEC's Division of Investment Management and my former colleague. And really thrilled to have Melissa here. Melissa was one of the key attorneys that worked on this rulemaking at the SEC. And she's been involved in this topic for quite a number of years now, and she has a lot of great insight as to what the commission came out with in terms of the new marketing rule. So thank you all for joining me here today. So as you can see from the slide, we are going to focus today's presentation on the new marketing rule, Rule 2064-1, which, as you heard Sarah Tansitov from the IAM Director say at the outset of the conference, that really merged the advertising and solicitation rules into one rule that we have here today. As John mentioned this morning, breaking news. We've been waiting quite some time now for the SEC's new marketing rule, which was approved at the end of December by the Commission to get published in the Federal Register, and it was published this morning, which means that the effective date, which is 60 days from that, will be May 4th, 2021, and I've done the math for everyone. That means the compliance date is going to be November 4th, 2022. So there's an 18-month transition period, and obviously there's a lot of work that needs to be done between now and then. So we're going to actually focus on the marketing rule. I do want to mention that when the Commission adopted the rule, they also made amendments to the record-keeping rule as well as Form ADV, and all I'll say about that is that really those amendments were really just tied into the marketing rule, the new marketing rule, and addresses issues that are to help really the examination and enforcement staff carry out their functions at the SEC. We're not going to have time to talk about those amendments today. We're going to focus purely on the marketing rule. Questions are important, and I highly encourage you to please type your questions into the chat box. We've identified a whole list of issues that we want to talk about today, but at the end of the day, we're here to sort of really answer your questions and make sure you have all the information that you need. So we'll try our best to answer your questions. The only thing that I ask as a moderator is this: if you could please try to be concise with your questions, maybe no more than 2 sentences if possible. I'm expecting, based on the webinars I've done recently on this topic, to get a lot of questions from the audience, and we're going to try our best to get to as many of those questions as we can. So, as John mentioned, the IAA and I know other firms and compliance consultants have done webinars, put out outlines, including the fantastic outline that Mike and K&L Gates put together that's in the conference materials, which I'm assuming everyone has read by now. I'm not going to assume that you all have read the 400-plus page adopting and release. That's a lot to ask. I have, and I know Mike has, and I think Pam has as well, and I'm hoping Melissa has as well. But what I do sort of anticipate or expect is that everyone by now has at least read the outline, maybe sat in on some webinars, so everyone has sort of a basic knowledge of what the new rule is. What we're going to focus on today is to talk about some of the gray areas, talk about some of the issues that we're seeing, that I'm hearing from members, that Pam is struggling through as a practitioner, that Mike is hearing from his clients, and then I think Melissa has probably been starting to hear from the industry. Really just focus on these issues that you all should be thinking about, provide you with some practical takeaways so that you can start your implementation journey. You have 18 months, but I know those 18 months are going to come fast, and so our goal here is really sort of focus on big issues for you to be thinking about starting today. So I'm just going to provide a really brief overview, and then we're going to dive right in. The IAA has been advocating for quite a number of years, even before I showed up there. Advocating that the SEC modernize the advertising rule in particular, and I know Melissa knows that. We've had lots of discussions with the staff over the years. We've encouraged them to make substantial changes, and we were extremely thrilled when the commission took that on as a priority. Ecstatic when the proposing release came out. We provided substantial comments. It's a 79-page comment letter, so we obviously had a lot to say. And then we were excited to see the final the outcome. I can tell you that on balance, we're really happy with the way that the commission came out. We think that the commission struck just the right balance between understanding the need for firms to be able to market their services, but also addressing investor protection concerns. One of the biggest pain points of the existing rule has been sort of the patchwork regulation that's come up. Everyone in this audience who's a compliance and legal professional knows how painful that is to have to digest a whole bunch of no action letters just to know what you need to do. So the rule, which is rather lengthy, really does, I think, a great job of trying to get all those topics into the rulemaking. It is principles-based. We'll talk a little bit about what that means. I think the key improvements are that there will no longer be any per se prohibitions on past specific recommendations or testimonials or third-party ratings. The rule, although not specifically, but does in spirit address social media, and we think also provides a sensible framework for performance advertising, and we'll spend some time talking about that as well. I'm not going to talk about too many of the changes from the proposals, but one thing that we were excited not to see make its way into the adoption is any new procedural requirement for pre-approval and review. We think that would have been an extreme burden, so we're grateful that we do not see that. But it is clear, especially from some of the statements in the adopting release, that the SEC does expect firms to have robust controls around approval, or just generally with respect to marketing. So that's sort of where we are. Why don't we start with an overview of the rule in terms of the structure of the rule. So the Advisors Act, Rule 2064-1, contains these provisions, the general prohibitions that I talked about. It has specific provisions on testimonials, endorsements, third-party ratings, performance. Then it has a section at the end on definition, including the definition of advertising. And that's where I'd like us to start off, and that's to talk about sort of what is an advertisement under the new rule, what's included, what's not included. And I know I said we're not going to spend too much time on sort of providing the details, but I do think it'd be helpful, at least on the definition, Mike, if you could just maybe provide us a very brief overview of the definition of advertising, set the table, and then we can have a good discussion on what's in and what's out.
Sure thing, Sanjay. Thanks very much. Thank you for that intro. I think that it is important to understand essentially what's in, what's out. Why do we care about the definition? It is because any communication from an investment advisor, direct or indirect, that fits either prong of this definition will be subject to the content standards of the rule. Unlike the current rule, we have two prongs. They're very different. The first prong is similar in many respects to the scope of the existing advertising rule. It captures any direct or indirect communication to more than one person, or if the communication includes hypothetical performance, to one or more persons. But the communication must either offer the investment advisor's advisory services with regard to securities to prospective clients or private fund investors, or in the alternative, offer new investment advisory services with regard to securities to current clients or private fund investors. Some important things that don't fit within this prong are extemporaneous live oral communications, information and a required notice for filing. If you look at Romanet 2 here, you can see that also outside this definition is communications with existing clients that don't offer new or expanded services, and also communications communications that are contain hypothetical performance information if they are directed either to an investor in a private fund, in a one-on-one communication, or in the alternative in response to an unsolicited request. So that's a pretty broad definition. There are several changes here, some new concepts that we'll talk about in the coming slides. But I don't want to leave out prong two, because prong two captures a lot of communications that historically have been addressed through the cash solicitation rule, but are addressed in a very different way under the marketing rule. Prong two makes an advertisement any endorsement or testimonial for which the advisor provides either cash or non-cash compensation, either directly or indirectly. And something that's really important to recognize here is that these are communications from third parties. So if you as the advisor are compensating a third party for that endorsement or testimonial, the communications that third party makes are your responsibility, and they must comply with the provisions of the rule. Now, we are, I feel, really lucky to have Melissa here with us today. Melissa, who knows this rule as intimately as anyone on the planet. And Melissa, my first question for you today, is it or is it not the case that your views on this rule reflect the views of the Commission?
Oh, good reminder for me. Thank you. No, the views that I expressed today are my own and in no way reflect the opinions of the Commission, any individual commissioner, or my colleagues on the staff. Thank you for reminding me.
That's great. So, Melissa, so we can expect you to be really candid with us today on your thoughts.
That's right.
I guess, Pam, before I turn it over to you, I did want to remind everyone for your CLE the first code word is rule, capital R, big A. So rule A with a capital A, R, capital A. Pam, so what are some of the issues that you're seeing on this definition that sort of jump out at you right away?
Well, my firm, we offer global equity, separate account and private funds to an institutional audience. So for me, one of the sort of biggest takeaways with the new definition is that a lot of what we do in terms of sales efforts has been in a one-on-one context, but we can't just simply rely on the one-on-one context anymore, and we'll get to that more in the next slide. The extemporaneous live oral communications, great. That covers my sales team, in their meetings. There is the caveat, of course, that if there are prepared or scripted remarks, or if it's, in the context of more of giving a speech, or if you're taking transcriptions and distributing them, then some of those materials would then fall into the definition of advertisement. As far as the required notices or filings go, I feel like that's very straightforward. However, if one kind of loads up their Form ADV Part 2 with salesy language, that could cross over into the scope of an advertisement. As far as hypothetical goes, in the institutional space, generally we've always been responding to specific requests for hypothetical performance about, a strategy that we could create for a client. So that I don't think much will change for my firm in that regard. But as we'll get to, there are some new things that are captured in the scope of hypothetical that will be something new and different for us to work through.
Great. So I'm getting some audience questions. Let me just take a crack at a couple of them. And Melissa, I have one question for you. But so the first question is, given the change in administration, can we expect perhaps the new chair of the commission to reconsider the advertising rule? I know, Melissa, you're probably saying you sure hope not. A lot of work went into it. I guess the comment that I'll make there is that, this is one of those rules that was voted on by the entire commission. It was 5-0 vote, including 2 Democratic commissioners. So I think there's a lot of support on both sides of the aisle for this rulemaking. Honestly, I don't think this will probably be a high priority for the new commission. So I am expecting this rule to go into compliance. And this will sort of be the new marketing rule that folks will have to live with. Now, of course, always down the line at some point, a commission may come in and tinker with it or might want to make some changes, but I wouldn't bank on it. The other question that I've received is on early compliance. Whether firms, can start, do they have to wait for the compliance date, or can they start complying immediately after the effective date? And Melissa, do you have any thoughts on that?
Sure. First of all, I would agree with what you said about picking this up with the new administration. I have not, we don't actually have our new chairman yet, so haven't had conversations with soon-to-be Chairman Gensler, but I suspect that this probably would not get on the regulatory agenda again. It was a 5-0 vote, and they worked very hard to get a 5-0 vote. So I don't see them revisiting it, but I don't know exactly what the chairman will want to do when he comes in. As far as having an opportunity for early compliance, I do think there is an opportunity. Should you choose to come into compliance early, I think that's fine. Under the rule, you're permitted to any time after the effective date. However, I would not expect firms to be able to pick and choose what they're going to comply with. So if you're planning on coming into compliance with some provisions, then I would expect to be coming into compliance with all of them. I think once you flip the switch, you're flipping the switch entirely.
Yeah, and we got a couple of questions on partial compliance, which you just answered. So that's great. Thank you for answering that. I think Pam, did you have any thoughts on firms that might want to come into compliance early? In terms of what they should think about.
Well, to Melissa's point, it's all or nothing. So in my mind, this is going to be a huge undertaking that is going to take many months. I am thrilled that we have basically 20 months from now to really get it all together. Not only are you going to need to look at all of your existing materials and figure out what may or may not need to change, where more disclosures may be needed, where you have to add net performance and different time periods. There's going to have to be policy review and revision, in some cases writing whole new pieces of policy to govern certain aspects. There's going to have to be extensive training of not only the persons creating the materials, your in-house sort of marketing teams, those folks that work on RFPs and databases, the actual salespersons themselves. And I would also add in all of your portfolio managers or product specialists that might participate in meetings and other outreach efforts with your sales teams. To get all of that lined up, all of your materials, your internal partners, and all of your policies and procedures polished. For me, I'm expecting this is going to take a year because, of course, we have the rest of our jobs to do all along as we're going through and preparing for this. So I think that people really need to take their time and be very thoughtful with this and have a really well sort of conceived plan and timeline before you just start willy-nilly kind of diving in. I would just really suggest a lot of thought and planning.
Right. Melissa, at Melissa's, at Sarah Tensitoff's, the division director's chat with, she mentioned that the no action letters is something that the staff is currently reviewing. And you're assessing whether they should be, withdrawn or partially withdrawn or what to do with them. Is that something you're going to publish at some point?
Yes.
Okay.
Yeah, it will be published. I don't know exactly when, but it will be published. I would expect that pretty much all of the letters are being withdrawn. Some of the letters touched on another topic, status or whatnot. And so those would get, withdrawn partially, but I expect that they'd all get withdrawn.
Right.
But we'll definitely publish that for sure.
Good. Okay, so let's get back to the definition of advertising and what's in and what's out. So as you can see from this slide, we've sort of listed what's in the definition and what's clearly out of the definition. I think all of these are specifically mentioned in the adopting release. So Pam, let me start with you. It seems like a fairly straightforward list. Are you seeing any sort of questions or issues here?
Yeah, so when I look at this list, the biggest change for my firm will be this notion of templates. So our sales efforts have always been, as I said, in a one-on-one context. It's an email outreach to an individual at an entity or at an investment consultant. It's a virtual or in-person meeting with one or more persons at that entity. The challenge is the fact that we use what I would call standard or master presentations. And so while page order may change, the content is the same for a given strategy across various meetings. And that is now going to be in the template camp, which means that the presentation itself is an advertisement, regardless of the one-on-one context. So we are going to have to revise all of our templates to meet the new requirements for performance, fair and balanced disclosures, et cetera. Bulk emails to me has always been clearly an advertisement. There's no surprise there. Commentary could present a challenge for some folks where, you have your couple paragraphs discussing the markets, but then you throw in the paragraph about how your strategy performed in that market environment or over that period. White papers, investment theses, et cetera. As far as the outs go, there's nothing here that, really jumps out at me. There is the notion of private fund materials, and whereas your PPM or your OM, the information in there that's about the terms, the objectives, the risks, that's not at all considered an advertisement. But to the extent that people are putting more information into those offering materials, including performance information, they could, cross the line into the advertising realm. And then I guess, overall, and I think we'll probably talk about this a little more, the concept that pieces of a material could be an advertisement where other parts are not. And I think that will be sort of a new concept where it's not necessarily it is or it isn't, but portions of something could be an advertisement.
Mike, can I ask you to jump in here with any observations?
Yeah, I think that's a very important point that Pam just made. And we see that concept reflected in the adopting release in a couple places. We see it in the discussion of PPMs. We see it in the discussion of RFPs. And I think, in fact, I should probably pose it as a question to Melissa rather than share my views. And the question that I have and that I'm getting from clients is, how do we interpret this in the context of an RFP? Because it's pretty clear, I believe, that promotional language, if it is canned language and it's placed in an RFP and maybe used in several locations, that language would be deemed an advertisement. But standardized responses that are factual in nature and responsive to the question, but by their nature are going to be responsive to any similar question that you get in an RFP, do they become advertisements simply because they're standardized? We're thinking about things like portfolio characteristics or Morningstar ratings, 10-year or 5-year performance. If that's what's requested, is it a response to an unsolicited request or is it an advertisement?
It's a good question. The fact that it's a standardized response, I would look at the way I would analyze it is to look at the material that you're talking about and first determine whether it would otherwise fit in the definition of advertisement before you consider the extent to which it's standardized. If the answer is yes, then the fact that it's one-on-one is helpful only to the extent that it's not a template. And then once you're in template land, you're looking at the requirements of the rule.
Okay, so I think when you say first ascertain whether or not it's an advertisement, you might be referring to the notion that an advertisement is a communication that offers advisory services or offers a private fund. And then I guess the brass tacks question here is performance always involved in offering, or if we're simply responding to a question, requesting performance without supplementing it with any promotional language, does that transform it into an advertisement?
Yeah, it's an interesting question because, I mean, I guess as I'm thinking about it, the way I would look at it is, if you're asked to provide gross, are you then required to then provide the net? And are you also then required to present it as 1, 5, and 10? And I guess the answer would likely be yes. If it's a template that you're filling out and providing over and over and over, then I guess it would be. Although, to the extent that you're answering and providing factual information in response to a question, could you make an argument otherwise? I suppose I could see the difficulty arising when you have, and I know Pam and I have talked about this before, when you have a database, or you don't have the ability to provide anything other than what has been asked. Can you attach or can you supplement? And that's that one is, to me, a harder question, and one that I think I want to take some time and think about, and perhaps take back to my colleagues as some place where, in my view, there could be some room. But again, I'm only talking my view. I don't think the outcome of the rule would have been, if you can't provide 1, 5, and 10, and you can't provide net because there's no way to attach it. In my view, it would not be acceptable to say you simply can't participate in an RFP. But again, it's my view. So that's something I would like to go back and think about further with some of my colleagues. I don't know if that's entirely responsive if I meandered too much from your question.
So let's take it out of the RFP context with a question here. Say you have a firm that provides a quarterly newsletter, which includes market commentary. Sometimes they discuss performance for the quarter. Given that commentary is considered in for purposes of advertising, will the prescribed time period apply where you can ask them to please state the performance of the preceding quarter?
I'm sorry, the last bit of what you said, I dropped off a bit.
So would you be required to put in the prescribed time periods if you couldn't state the performance preceding the last quarter, if you don't state that performance?
Because you otherwise would be providing the quarter instead of this prescribed 1, 5, 10.
It's a quarterly commentary, so you're just talking about what happened the last 3 months. Yeah.
And this is going to existing investors?
From the question,
frequently they're made public. So in some cases, they'll.
Okay. I mean, I guess so. The rule doesn't preclude you from providing additional performance information. So if you want to, if you're providing the quarterly, then I suppose as a backup attachment, then you would be providing also the 1, 5, and 10 and the gross and net. But there's nothing in the rule that prevents you from providing something additional. So if you provide 1, 5, and 10, and you also particularly want to talk about the 3-year performance, or in this case, the quarter, there's nothing to prevent you from doing that. You'd be just looking at the general prohibitions and making sure that you're complying with those.
So, Mike, do you guys have any other observations on this deck before we move on?
By the way, I would have a different view if this was, in a commentary piece or a newsletter or something that's going to current investors, where you're showing them how the portfolio performed over a quarter. I think that's different.
Yes. As far as other thoughts, just before we leave this page, as I said, the bulk email concept to me is pretty crystal clear. Like, it's Dear John or it's Dear Jane, and it's the same email going to 2,000 people. Where I think it will be interesting, and this is something that I will have to parse through with my sales team, is to the extent that there's sort of like a template introductory language that a salesperson likes to use in their initial outreach email to a prospective client or investment consultant. If there's a couple paragraphs that they like to use in every email and they don't tailor it because it's talking about our firm and our investment offerings, even if they've tailored some of the upfront and maybe they tailor the closing, is that email or those emails, even in the one-on-one context, are they now treading into the space of being an advertisement because there is, again, this notion of standardized or template content? And I don't know if we have an answer here today, but it's something that at GlobeFlex we're going to have to think about, and I think a lot of firms will.
I think if you are looking at a template and a portion of a bulk email, then I think yes, you are looking at, provided it otherwise meets the definition. Again, if it otherwise meets the definition, then I think you are looking at triggering the rule.
Right. So then the one-on-one email becomes an advertisement, and now I need to figure out how we're going to build in a whole bunch of disclosures at the bottom of the email. So there's a lot of the practical application of a lot of this stuff is, back to my point that this is going to take a lot of time to really think through and really plan for.
I do think you'd be only talking about the template proportion, though. I don't know if your question, so you did take that as okay, sorry. You appreciated that fact. I wasn't sure. The whole thing wouldn't be, but the
right.
template portion would be.
Right. And if the template portion is talking about, and we'll come to this concept, the potential benefits of engaging my firm to manage your assets, then there are going to be required disclosures that have to go along with that discussion of benefits. So.
Do you have any other observations on this before?
No, I think we have a lot to cover. We haven't even gotten through the definition yet, so we should probably move on.
Okay, so as Mike noted, prong one of the definition applies to direct or indirect communications by the advisor. So, Mike, do you want to maybe just kind of tee this off and talk a little bit about what the commission intended by indirect in particular?
Yeah, absolutely. So this is not an entirely novel concept that if an investment advisor causes a third party to do something or takes third party content and redistributes it, that the investment advisor would be responsible for that material in the form of an advertisement. I think that what we see here in the rule is a codification of those concepts and a discussion in the adopting release of the concepts of adoption and entanglement, which have a predicate in federal courts and in staff guidance and FINRA guidance, and now they're in the adopting release in the form of guidance. And really, what this means, that the concept here is that an investment advisor will be responsible for an indirect communication, and that communication will be an advertisement under the rule if the investment advisor either takes third-party content and does something to cause the public to think that the investment advisor is responsible for it, or agrees with it, or disseminates it, or otherwise adopts that content as its own. In the alternative, the investment advisor would be responsible for that content if it's involved in the creation of the content. And this is the entanglement theory. It's entangled in the creation of the content in the first instance. The good news here, though, is that it's fairly clear, to me at least, and Melissa, you can correct me if you want to, that an advisor needs to take some sort of affirmative steps in order to be indirectly responsible for content, with the possible exception of content that's redistributed by affiliates. And what do those affirmative steps look like? You can see we have them here on the slide. Did it actively participate in creating the content? Did it do something to cause a person to think that third-party content is its own or is content that it agrees with? And by contrast, very helpfully, there are some examples where content that is either edited after the advisor has created it, or if the advisor is hosting a site on social media, we'll talk about social media more in just a moment, if the advisor isn't soliciting the views of third parties on certain topics, and it's not revising or amending the posts of third parties, I think very helpfully. Thank you, Melissa, and to anyone else on the staff that is listening. We now have it fairly clear that the advisor is not responsible for that content of third parties unless it's taking some action to change it or agree with it.
Nothing to correct. You're right.
So Pam, I know we've had some member calls to talk about some issues and some particular issues on sort of what this component means that's been coming up. I know you want to mention one in particular.
Yeah, I mean, it's come up in a couple different previous sessions that I've been involved in, is this notion of CITs, where an advisor is acting as the sub-advisor for a CIT. And often in these cases, the advisor is very much entangled in the creation of the fact sheets for that CIT. The advisor itself isn't necessarily using or distributing the fact sheets, but they're providing a large part of the content to the CIT sponsor, or they're even, in fact, essentially creating the fact sheet with their own look and feel of their other materials. And it's a question that we've already talked about, but I'll pose it to Melissa again. Does that entanglement in those CIT fact sheets cause them to be advertisements of the advisor?
And my answer is no. The rule is intended to apply to, separately managed account clients and private fund investors. So that it would not extend here where it would be delivered presumably to collective investment trust investors. So if that material was then redistributed and given to the advisor to try to get private fund clients to say, hey, look what I can do for you, or to, for a separately managed account to say, look at this wealth of experience I have, that's a different matter. But otherwise, for CIT investors, no.
And Melissa, that analysis would extend to UCITS or ACE or 3C5 funds or any other product that is not either advisory or private fund, 3C1 or 3C7.
Yep.
Right? Okay.
Absolutely.
Yeah, and then another sort of in this intermediaries and distribution by third parties concept, at least in the institutional space, a large part of our sales interaction is with the institutional investment consultant firms, many of which are essentially the gatekeepers to the plan sponsors. And do we need to be concerned about providing a pitch book to an investment consultant who then turns around and provides that pitch book to their client? Is there anything we need to be wary of there?
I think we talked about investment consultants a little bit in the release, and the extent to which they're, on one hand, so they're acting on behalf of their clients. So, to the extent that you're distributing to an investment consultant, I would treat it as you're distributing to a client. I haven't thought about the extent to which to whom they're turning around and disseminating it. I guess if it's going to more than one person, then you probably are treating it as an advertisement. But if you know that the investment consultant is giving it to one, then you're outside of the advertisement rule, the marketing rule. And if you don't know, that's a good question. That would be I would say that'd be an interesting question. If you don't know, I don't know how much you would want to stick with the rule or not. Again, one of the many things that we're all going to have to sort of really parse through as we digest and think about implementing under the new rule. And then I guess the other sort of point on the out column here, employees' personal social media is out if there is oversight and supervision. And so back to the point on policies and procedures, our policies and procedures need to be clear that employees' social media accounts are not to be used
for marketing, and we're going to have to train and remind and monitor, and maybe go so far as collect attestations where you can't monitor. But just an important point there on the sort of back end, the procedural side of what that means.
One thing I thought might be worth noting as you're talking about this, it got me thinking about one change that I think is noteworthy that I don't know is super apparent on its face. It's certainly not apparent from looking at the rule text. But this rule is actually held to a different standard. The original rule, the current rule, is a strict liability rule. I think it's worth noting as you're thinking about policies and procedures that we're looking for, reasonableness here, and that the current rule, the new rule, actually has a negligence standard with it. So it is not going to be picked up, just for purposes of a strict liability. Foot fault should not be, something that you should be worried about under the new iteration of the rule. I think that's an important change, but I don't know.
So we're getting some questions.
Although you don't speak for the commission, do you speak for the Division of Examinations and how they are going to rule in the examination context? Or could we perhaps quote you on this occasion when it comes time for those conversations?
Just look for the word negligence in the adopting release and cite it.
Okay.
So Pam, you mentioned social media, and we've been getting some questions on that. So why don't we, in the interest of time, move on? So Mike, as I noted, it's not specifically mentioned anywhere really, but really the principles are there. Do you want to talk to us about sort of how this will work in the social media context?
Yeah, there are a series of changes and aspects to the rule that, to your point, aren't readily apparent. But when you read the release, you can see that there are some changes here, and we start to see some cohesion around how to approach social media. I think it, respectfully, Melissa, could have been a little bit more, clear, but it's all there for people who want to go and find it. Some of these changes are, first of all, to one of the big changes in the rule. An endorsement is now defined in the rule, and firms are responsible for compensated endorsements. And the extension of that then is that third-party content on a website that is uncompensated we're going to start from the presumption that it's outside the scope of the rule. There's no per se ban on endorsements and testimonials, which gives us a different framework to think about content posted by third parties on social media. The concepts of adoption and entanglement are no longer within the realm of staff guidance as applied to this rule. They are now stated in the adopting release. So we have a good sense for how the commission wants us to approach those interpretive matters. And hyperlinking is also discussed. Now, hyperlinking is discussed primarily in the context of interpreting what sorts of disclosures satisfy the various requirements and the general prohibitions that we'll talk about in a moment. But this, I think, is really important because once we start pulling all of these concepts together, we get to a place where it will be a lot more feasible for firms to understand and implement their social media presence in a manner consistent with the rule. A way that I've sometimes put this is the rule has been updated in these respects to be more relevant for 21st century influencers rather than 20th century touts. And in addition to all of this, there's helpful guidance in the rule that notes that around the use of social media by firm employees, stating essentially that an advisor that implements effective procedures and policies around the oversight and supervision of its employees, and that trains those employees to understand the importance of not inadvertently or for that matter deliberately using their personal social media site as an opportunity to promote the firm's services, that firm would not be presumed to be making advertisements if the employees deviate from that standard. I think all of this together is very helpful guidance for social media, even though you won't see social media expressly discussed in the rule text.
So what was sort of the thought process? I know part of the objective here was to make the rule sort of evergreen. I'm assuming you agree with sort of what Mike just said, but so what was the thought process of not sort of addressing maybe social media a little bit more head on and some of the concerns?
In not addressing it more?
Or more head on, I guess being more.
I don't know that we thought about addressing it in that way in particular at all. I mean, normally when we describe, when we go through a rulemaking, each part of the rule, and this is very boring nuts and bolts rulemaking process, but we seek to sort of break it down into all of its components and explain each individual component. And there's a thought as to how it's going to work as a whole, of course. But I don't know that we go into that so much when we're talking about it in the release. So to address this context versus another context, I think it probably would have been a potentially infinite list. We would have been talking about social media. We would have been talking about paper. We could have talked about television. We could have talked about radio and so on and so forth. And we really tried to be as media neutral as possible. And so I think that would probably be the upshot of why it isn't singled out and discussed. It's not that it wasn't thought of, because we had to think about all of the different types of media to make sure that, what we were doing was going to work on a small screen and work in print and as best you could in a, rule of general applicability.
Yeah. So Pam, do you have any thoughts on social media under the new rule before we move on?
Not really, honestly, as it relates to my firm, because it's one of, I guess, the blessings of being in the institutional space is that it's not a marketing channel for us. But as I look at it, just stepping back a bit, I do think that one of the practical applications of some of the new disclosure requirements will be interesting, if not challenging, for folks in some digital context where there's going to be certain pieces of information that have to accompany a testimonial or endorsement, like in the moment, right there. It can't be buried. It can't be, on another website. And how a firm's going to work that all in so that they meet the requirements will again be just another sort of process that has to be worked through, and we'll take some. I think people are going to really have to look at the ways they're using social media and other digital avenues, and really figure out how they're going to meet all the new prohibitions and requirements in those contexts.
All right, so
Sanjay, to move on, there's a great question sitting in the chat box that I think we should field here. And the question is, by the nature of social media, would a retweet or reshare of a third-party post then fall into the category of endorsement, and therefore the advisor is responsible for the content being shared? And it's a little bit unclear here, but I think the first thing to think about is if you have some third party out there in the world that retweets or reshares your post, or some third party's post that says something nice about you, that might be an endorsement. It might be a testimonial, but it's only your advertisement if you compensated the person who's doing it. So if you have, there are these services out there that will amplify your online presence by creating fake accounts and by posting them around and sending around information about you. Those, if you are engaging a party to do that, those are compensated endorsements. But if someone is out there doing it on their own, it might be an endorsement, but it's outside the scope of the rule.
Okay, so let's move on to the next topic. So as I mentioned at the outset, the rule has a section that lists out various general prohibitions. And, I think some of the key points here is that, as the commission noted in the release, that, for all of these, it is really going to be a facts and circumstances analysis. You should consider and factor in the nature of the audience, which we thought was very helpful, particularly clarifying that it would apply to all of the elements. I guess from my perspective, a lot of these, and I guess Melissa, I'll ask if you agree or disagree, but I mean, I think these are general principles that folks should be familiar with. They really stem from and are an outreach of the general anti-fraud provisions that are there. And there have been enforcement actions, staff statements. So I mean, I think these are principles that people are familiar with. I think what's maybe tripping people up that there's a lot of specific types of facts and scenarios that are mentioned in the release that are maybe causing some confusion or some lack of clarity. Pam, and first, I guess, Melissa, let me ask you: do you agree that these are principles that are really sort of were intended just to maybe codify with whatever is out there? Okay.
Yeah, they're really intended to be drawn from current general anti-fraud principles from a variety of contexts. A good chunk of them from a no action letter or otherwise. The rule is escaping me. The rule is escaping me. Sorry, it's Friday afternoon. There's another rule that it's drawn from.
But we have
33X space.
So on one hand, we think it's important and we welcome a more principles-based approach, but that does raise questions on some of how this plays out. And Pam, you're nodding your head. I mean, are there issues that you're seeing here that folks should be thinking about?
So, I mean, the first three to me are cut and dry and shouldn't be a surprise to anybody. The fourth prohibition, as it's laid out, fourth bullet here, this is the one that I'm struggling a bit with because the release says that when you provide a discussion of potential benefit, you have to provide a fair and balanced disclosure of material risks and material limitations. And what I'm struggling with is what falls into the camp of a discussion of potential benefit. Does it need to be like descriptive language about how wonderful an investment advisor we are and the wonderful experience you could have as a client of ours and the potential strictly from a performance aspect of what you might expect from one of our strategies? Or is it really like any discussion or presentation of information about our firm or our strategies? And it matters, I guess, because for me, it's going to determine how much footnoting and disclosure I need to bake into every advertisement. And in the case of a pitch book, how many pages of that pitch book need to have discussion of risks and limitations on them? And I guess even a broader question is, can the pitch book as a whole or the advertisement as a whole be considered the discussion of benefit? Or does an advisor really need to go through each piece or portion or section and determine if there are individual discussions of benefit and have footnotes accompanying those?
And I think you raised a lot of good points. And the fact that this is this in particular, this part of the rule is principles based, does present some challenges because you get a lot more flexibility, but then a lot less certainty when you don't have a black and white rule put in front of you. And I would say that I hate to give the answer, it depends. I feel like it's the classic law school answer, but I really think it really depends on facts and circumstances. So would I say, just listing, the countries in which you happen to be invested in, is that a benefit? Probably not. But then if you're describing yourself as being well diversified and using that as an example, or that strategy is well diversified or portfolio well diversified, now you've probably pitched it more as a benefit. But then, there's also, there's a few things to take into account. So going back to something that we heard a moment ago is we did say at the very beginning of the general prohibitions, or I shouldn't say the commission said at the very beginning of the discussion of general prohibitions, to consider the nature of your audience. So I think some of how you're going to be presenting information and disclosures it's going to depend based on who your anticipated reader would be, or your audience, not necessarily an individual reader. And when it comes to this particular prohibition number 4, the goal of it really was to get the material risks and limitations associated with a particular benefit within the context of the discussion. So if you're thinking about the totality of the entire advertisement and keeping the entire, really being true to what the commission was looking for there, I think probably keeping the discussion of the risks and the limitations fairly close in proximity to a discussion of the benefit. So if you're talking about a 60-page pitch book, I probably wouldn't separate them by, 58 pages. But if one happens to be on one page and the other happens to be on another page, I'm not sure that that's the end of the world either. I think it really depends. And I know that in some respects that's probably a fairly unsatisfying answer, but I really do think a lot of it is contextual, and a lot of it is based on the nature of the audience.
Right. And then, yeah.
Oh, sorry, go ahead. No, please, no, you.
The nature of the audience point, to what extent do we as CCOs, compliance personnel, do we need to have some sort of backup record of who the intended audience was at the time that the piece was created or disseminated? Or, if I simply know that we market to an institutional audience, is that enough? Would that satisfy, say, an examiner? And I'm sure you can't answer that, but that's another sort of piece of this that I'm grappling with, is how much do I need to do to sort of prove our reasoning when it comes to the nature of the audience?
That's a good question. I don't know if we answered it squarely in the release. I can't recall off the top of my head. But Mike might have some thoughts from coming at it from the perspective of counseling clients.
So I look, you need to have an answer to that OC or Division of Examinations examiner. I think my personal view is that if GlobeFlex prepares presentations and manages products that have a $5 million minimum or a $25 million minimum, right? That the combination of those two facts is very compelling to show that you are presenting to institutional audiences, right? Not everybody has those facts. And if instead you're at a manager that has both retail and institutional clients, then that manager might be in a position where they would want to take extra steps to document the recipients.
Good point.
Okay, so I'd like to move on unless anyone has any other issues they'd like to highlight here. We're good? Okay. Okay, so again, I'm not going to go into the definition. The definition is here as a point of reference. Basically a testimonial is a statement by a current client, endorsements, anyone other than the current client. There are two prongs, and we've been getting a lot of questions sort of the interplay between prong 1 and prong 2, particularly as it relates to testimonials and endorsements. Mike, do you want to quickly just maybe kind of explain the differences here and how this is set up?
Yeah, absolutely. I'm going to start with the second prong, and then we'll cycle back around to the first. So the second prong of the definition of an advertisement, as we recall, is that a compensated testimonial or endorsement by a third party is an advertisement by the advisor. And that applies to oral communications in writing, regardless of the number of people who receive it, and the manner of compensation is very broad. It's direct, indirect compensation. It could be in kind. It could be reductions of fees. We understand generally that this applies to third parties. An often overlooked aspect of the rule, in my experience, is what I'm going to call the more traditional use of a testimonial that we're accustomed to these days, which is if a third party says something nice about the advisor, And now it's a client or a non-client, and the advisor then publishes that information. It doesn't matter whether the testimonial or the endorsement was compensated, because now the advisor is the party that's responsible for making the communication. That is a first prong advertisement, and the testimonial or the endorsement will be subject to all the requirements, or those requirements that are applicable to the testimonial or endorsement, because the advisor has pushed or has adopted or has been entangled with the creation of that communication. And this is why we see within the rule certain aspects of the rule that are applicable to uncompensated testimonials and endorsements. Those matter because there will be circumstances where the advisor republishes the testimonial and the endorsement. So the way to think about it is a prong 1 testimonial is something that the advisor pushes. A prong 2 testimonial is something that the advisor paid a client to say to third parties. Same is true for endorsements.
Great. So you mentioned various different requirements depending on the fact scenario. So we came up with this chart. Mike, you want to just quickly explain what this chart is, and then maybe we can talk a little bit about some of these issues?
Yeah, absolutely. So within that section of the rule that has very specific requirements about what needs to happen if an advisor includes in an advertisement, directly or indirectly, whether the advisor communicates it or the third party communicates it, certain requirements around testimonials and endorsements. And as you can see, on the left-hand side here, we have various descriptions of the types of endorsements or testimonials that can occur, and across the top, indications of what requirements apply. So a couple points that I'll make initially is that in all of the cases, the communication will be subject to the general prohibitions that we saw a couple slides ago to ensure that the communication, and that's true whether there's no compensation, de minimis compensation, whether affiliates are stating it, all situations. Similarly, the advisor in all of these situations is going to be in a position where it must have a reasonable basis for believing that the testimonial or the endorsement complies with the rule. Usually that is going to involve some sort of policy or procedure or oversight or testing or review. And my view and my read of the rule is that there's actually, the advisor has many degrees of freedom to apply how to develop that reasonable basis depending on the facts and circumstances. That's not very specifically described. Now, in the other columns, we have obligations with respect to testimonials and endorsements that differ depending on the type of party and the circumstances of the testimonial and the endorsement. I won't go through all of them, but the quick story here is, in some cases, there needs to be a written agreement, particularly for compensated testimonials and endorsements. In most cases, you have to ascertain whether the party giving the testimonial or endorsement is subject to a statutory disqualification. And then in most cases, really any situation other than where affiliates are making the communications or certain broker-dealer communications, we do have required disclosures. And those disclosures really come in 2 parts, with the first part being a brief statement of very material issues, the relationship, whether a compensation was paid, any major or material, I should say, conflicts. And the second part being a more fulsome disclosure that, we should point out, the commission very helpfully said could be hyperlinked from the testimonial or the endorsement.
So Pam, are you seeing any sort of implementation or issues here that you'd like to highlight?
Well, we do all of our own marketing and sales efforts in-house. So, we'll really fall into the affiliated personnel camp. I think, there is a requirement that the affiliation be clear, readily apparent, and accompany the testimonial or endorsement. So, in the case of my team, it's just going to be reminding them that, include your email signature on your emails, hand out a business card when you're at in-person meetings, or make sure that, your employment with GlobeFlex is clear on the cover page of the pitch book. I don't think that you can simply rely on, the extension of your email address. You can't rely on the fact that you're listed on the website per se. But that's an easy enough, the readily apparent thing is easy enough to accomplish. As far as the disqualifications go, I think the question that I'm asking is there anything different, or anything that I need to do differently on an annual basis as it relates to the disqualification provision? We do have proprietary private funds, and so there are covered persons that I'm already putting through the 506B sort of exemption test every year via a questionnaire. Melissa, I guess I'll let you speak to the disqualification point.
Sure. First of all, I love this slide, by the way. I think this was really well put together. It encapsulates everything really, really concisely. So as for the disqualification, I guess what I'd share here is what we really were looking to do was to make it as painless as possible. So where you have de minimis, there's probably not so much bang for your buck to apply the disqualification. That seemed like an easy place to remove it. Where you have uncompensated, same thing. Where you have a broker dealer, it seemed like you would best situated to look to the 34 Act and what is already applicable to that broker dealer as making the most sense as applying, and being probably the least painful for you to then think through whether they're disqualified. Same thing with 506. You're already looking at it for a 506 offering, and then otherwise for anything that is current employee or somebody who doesn't fit into one of those other categories, you're applying a standard that we expect you would otherwise be familiar with because it's the Advisors Act standard. So that was really the thinking behind that.
So we're running short on time. I just want to the second code was capital R rule, capital B. So we're running short on time. I'd like to sort of pull an audible and maybe switch, not address third-party ratings and make sure we get to performance. And I'd like to sort of dive right in on some issues that we're sort of seeing and we've talked about. Pam, do you want to maybe start us off on some challenges here you might see?
Yeah, sure. Practically speaking, for I think most advisors out there that aren't already using net performance, you're going to have to make that change in all of your template materials. And the inclusion of the 1, 5, and 10-year performance period, every advertisement is going to need to, if it presents performance, be in a net context or gross and net, and present those 3 periods. I think it's clear that you can present other periods, additional periods. You can present additional metrics in that same piece, but you've got to include net returns for 1, 5, and 10. One of the potential challenges for firms is going to be this notion of representative accounts and related performance. To the extent you're not using composites and you have a lot of accounts under management, I think you're going to want to take a hard look at this piece because there is a requirement for an analysis of materiality, basically so that you can ensure that you're not presenting the one account that had the absolute best or better return than every other account under management. And so, firms, and there is plenty of time to do this, may want to go down the path of creating composites to the extent that they're not already working in a composite sort of realm. The other, I think, very interesting thing is the sort of expanded definition of what is hypothetical. Importantly for us, a simple statement like we would expect to outperform the index by 300 basis points over a full market cycle, that now is considered to be a hypothetical performance statement. So, back to, again, RFP language, sort of statements that may be used in a lot of, advertisements, that now is going to have to be accompanied by explicit disclosures. And I'm just looking here over our list. Portability, I think, is pretty straightforward, but that's not really my bailiwick. Mike, do you have any other thoughts here?
Sanjay, if we have one more minute, there's a question I would love to pose to Melissa.
Yes.
You're getting compliance a lot. So, as you know, Melissa, the rule requires that gross and net, and also that net and 1, 5, and 10 be presented with equal prominence any time that performance results are presented. In practice, a lot of times there's going to be a 50-page flip book that, in the manner of presentation doesn't always lend itself to that requirement. Attribution is typically calculated off of gross performance. Some firms will want to show maybe 1, 5, and 10 on one page and then show 3-year rolling periods a couple pages later. The question that we have is it adequate to prominently show net performance and 1, 5, and 10 performance prominently one time? And obviously facts and circumstances will be important. Or does every presentation of every type of performance always need to be done on a net basis and across 1, 5, and 10-year periods?
And I think the answer is no, I don't think you have to do that every single time. So, the requirement is to put in the net when you put in gross, and 1, 5, and 10 has to be in there as well. And if you choose to put in additional information, if you choose to do attribution, as you said, or 3-year Sharpe ratio, or something else that you think would be informative and you want to provide to an investor, I think it's fine. I think you're looking at the general prohibitions, and you're considering the nature of your audience and the totality of the material that you're looking at.
That's great. And by contrast, if I put the net performance on the 60th page, that's probably not equal prominence, right?
I think that's probably right. So do they have to be side by side? No. But if it's, page 2 and page 3 or page 6 and page 7, I'm sure that also is, equal prominence given the context of the entire piece.
Okay. Thank you so much.
Yeah, thanks for that, Melissa.
Sure.
So we are out of time. I knew this would happen. We gave this panel an extra 20 minutes. Still ran out of time. We had a lot of questions, and I'm sorry to folks that we couldn't answer all the questions. Certainly there will be a lot more to say on this during the 18-month implementation period. So I'd like to ask each of you one question, and that is, what are your sort of final thoughts and final recommendations to folks who are in the audience in terms of what they should be doing now to start thinking about their implementation? And Melissa, I'd love to ask you that question, but I'd also like to ask you to see, what guidance or can we expect from the SEC or help can we expect from the SEC staff in terms of potential FAQs along those lines? So I'd like to maybe start with Pam, and we can go from there.
Sure. I mean, my personal timeline, given other things that happened in the first quarter, like audits and ADV filing and all that, was take this quarter and part of the next quarter to really digest the release. I have read it. I suggest everybody read it because there's a lot of really interesting examples. Often they're in the footnotes, but I think it is worth everybody's time to really parse through the release, and then gather sort of the industry insight from the law firms and the compliance consultants and conferences like this. My next step is going to be to inventory all the materials and start wrapping my head around what needs to change, and then present sort of the key points of the rule and what I believe needs to happen to senior management and the marketing team, and get us to agree on a timeline and then start working on the conversion.
Right.
So I would endorse everything that Pam just said, and I would add to that under this rule, compliance officers and in some cases in-house counsel are going to be called on to make many more judgments and judgment calls than they have under the current regime. There is not an established set of conditions for reliance on a no-action letter in as many cases as there have been historically. And I think that the compliance team needs to steel themselves for that over the coming years, and probably also needs to have some discussions with senior management about how best to approach that. Because in practice, everybody who is attending this particular conference knows that they will have salespeople pushing them and pushing them and pushing them to extend what they consider to be fair and balanced. And that's going to be an interesting new dynamic for a lot of compliance departments at a lot of firms, and we got to get ready for it.
Right. Melissa?
Sure. So I would say, first of all, I know the release is long. If you can read it, but understood, you can't make it through the entire thing, but know that you have excellent resources on your hands who are probably a phone call away from you. I can tell you that I personally talked with Sanjay and Mike in particular a ton during the entire process of both proposal and adoption. They and their colleagues are extremely well versed in this topic. They're a terrific resource that you have for you. And you can also feel free to call the staff. It wouldn't be appropriate for me to commit one way or another as to whether we're doing FAQs, but I can say that in my 12 years being there, I don't think I know of a set of rules that we've adopted that we haven't done FAQs on. That said, we haven't heard a ton from people. If you don't feel comfortable calling us, call Sanjay, call Mike, call somebody that you think might be able to get that burning question to us if it's something that, you think needs to be addressed.
Thank you for that. And we really appreciate your willingness to engage with us and to talk to us about some of these issues. So we very much look forward to continuing that dialogue. So thank you for that, Melissa. And I guess I'll just sort of put in a final plug. I mean, obviously at the IAA, we were developing a lot of resources. We have a dedicated page on our website for members to start helping with the implementation. We're going to do more webinars. Mike's done some webinars with us. We'll continue to do more. And we do have an implementation group that's meeting on a regular basis. That group will work through some of these issues for the coming 18 months. So we are out of time. I want to thank each of my panelists for the fantastic job. Melissa, Mike, Pam, thank you so much for participating in today's panel. I really appreciate it, and I look forward to continuing to talk to you guys on these issues. So thank you very much.